So, Mr. Bukovich, I'll give you 2 weeks to figure out how to tell your client to behave in my courtroom.
Stephanie Can on behalf of Ms. Cummings. Ms. Cummings, could you please state your name for the record?
Ajane Cummings.
Your Honor, I do have a green sheet for her. When appropriate, I'd like to address bond.
Probable cause conference will be adjourned April 2nd, 2026, 9 a.m. As to bond.
Thank you, Your Honor. Your Honor, currently, my client has I do believe, a $10,000 bond in this particular case. We're asking if the 10% provision, $1,000 bond. We're asking if the 10% provision could be added to it. In addition, currently, she is not allowed to go home.
I have it as cash surety 10%.
I believe this is the one that said $1,000, right? You told me you can't do 1,000.
Yeah, I can't do 1,000. I don't know if it's 1,000 or not. I don't know.
Your Honor, I believe it said 1,000. She can't do 1,000. She's asking for it to be lowered to 100.
Okay.
So, Your Honor, the bigger issue here is that right now there's a no-go to her home.
Yes.
And she wants to be able to go back home. In this particular case, as I read it, my client has some mental health needs. And while she was at the house, her boyfriend did call to get some help. However, when the police arrived, it's my understanding that he was trying to just explain that to him. But instead of that, they had her try to leave. She didn't understand why she needed to leave because it's her home. So then she winds up getting additional charges out of it, Your Honor. But he wants her home, and she wants to be able to go home.
I have a response.
Your Honor, I don't think we've had any contact with the homeowner. I do recall this case. I'd asked the body, and she was being asked to leave this home, and that's about the situation.
Good.
Your Honor, it's a police resisting matter. It's not a domestic violence.
I see the charges, but I'm trying to figure out, but I also see the bond condition. So I'm trying to figure out whose home is it?
It's her home. She lives there with him. They live together. So this is not a domestic violence case.
I know, you said that.
I understand, Your Honor.
Acknowledge that.
The premise usually is you can't go back because of DV, not because you resisted the police at your house.
Okay. I guess I'll agree with you, but this condition is here because whether charged or not, there was some altercation that occurred there, correct?
Your Honor, yes. It's my understanding it was welfare.
Alleged altercation.
Yes, it was more about welfare due to her mental health. He was trying to get help, and it turned into this. My apologies, Your Honor. Please continue.
No, it's like when people talk to me, I actually hear them. But if you want to keep going, go.
I do not, Your Honor.
Oh, if you want to keep going,
I absolutely.
I just hearing patiently.
Nope.
So the only question, if they both own the premises, is that what I have? Or is it just he may own the premises, but she resides there?
Yes, Your Honor. Yes.
To which one?
He owns it. It's in his name and everything, but like
lived there.
Yeah, for the whole time.
Okay.
Like I helped him. I'm sorry.
No, it's okay.
That's a problem.
I just have to. No, she's doing good. You are my problem.
I understand that, Your Honor.
So, ma'am, how long have you lived there?
I've been living there the whole time since we got there. December 3rd of 2025.
Okay, gotcha. Okay, so here's what I'm going to do. I think she has a 10% privilege on the bond. I will set her bond at a 1,000 10%. I'll just clarify it.
Thank you, Your Honor.
Right. So I'll set it at that. I'll adjourn this out instead of 2 weeks out. I'll adjourn it out to next week, 2026 at 9. That'll give them time to check with
what was the
him and
what was the date? I'm sorry.
26, 1 week out. Okay. So instead of 2 weeks, I'm going to go 1 week. I've made it clear on your bond is a 10%. They're going to check with him. If it's okay, then release it. If they check before this date, It's a written order to me, and I'd sign off on it.
Okay.
Thank you, Your Honor.
Okay.
Right.
At this point, however, well, the bond is set there, but,
Okay.
and ma'am, so that we're clear, if you post this bond
Yes.
before we get clarification, you can't.
I can't go home yet.
Right.
The judge has separated two issues that the defense initially tried to combine: the financial bond and the no-go condition. Clarifying the 10% provision may make release financially possible, but it does not automatically authorize Cummings to return to the residence. Defense counsel argues that she lived there and that the incident arose from a mental health welfare call rather than a domestic violence allegation. That distinction helps explain why counsel challenged the restriction, but residency alone does not invalidate a court-ordered bond condition. The judge is concerned about what prompted police involvement and whether the homeowner genuinely wants her back. Notice how carefully he establishes that the boyfriend owns the property while Cummings merely resides there. He then creates a controlled procedure: verify the boyfriend's position, submit a written order, and obtain judicial approval before changing the condition. That protects Cummings' potential housing interest without gambling with safety or relying solely on second-hand representations. Would you have removed the restriction based on defense counsel's explanation, or would you also require direct confirmation from the homeowner? The accelerated court date shows that the judge recognizes the urgency while refusing to make an unsupported decision.
Okay, now how do he get in contact with them, if you don't mind me asking?
I have no idea. They're not using my phone.
Okay. All right.
All right.
Thank you.
Thank you. Court calls the case of the people versus Warner, Ali Thomas.
Check well, speak to the people.
And assistant public defendant Nick Bukovich for Mr. Ali Thomas, who is now approaching. Mr. Ali Thomas, can you please state your name for the record?
Warner Victor Ali Thomas.
Thank you. I have before me a plea form that indicates the defendant will be pleading guilty charge of attempted resisting and obstructing a police officer, first responder, to 1 year offense. Upon is successfully to that charge, counts 1 through 3 would be dismissed. Well, yes, counts 1 through 3 would dismiss. And count 2. You guys are going to have to help me. I got 1 through 3 in this case would be dismissed. And then there's another 15th district court case where I don't.
I mean, it's a global resolution for to resolve court cases.
Okay.
The plea agreement would call for Mr. Ali Thomas to plead guilty to attempted resisting obstructing a police officer in the case before the court today. We will then dismiss counts as an added count 4, dismiss counts 1 through 3. Then we will dismiss 15th district court case number 26034 SM. The case in its entirety. We'll dismiss district court case number 260048 SM in its entirety. That's a larceny under 200. And count 2 in 15th district court case 260033 SM, which
is already at 15.
Already at 15. And then part of this is he's also going to plead guilty to attempted resisting a police officer in 15th district court case number 260033 SM.
All right. And then he's agreeing to pay restitution to be determined on all dismissed counts from the cases that we talked about here.
Yes.
And then there's a sentence agreement also to probation. Okay, that would be the court's full understanding of it. Is that your understanding, Mr. Bukovich?
Yes, that's my understanding. Also, in addition, APA Ajane Cummings, there's a city case that she indicated would be dismissed once these 2 cases are pled to as well. I believe that may not be on there, but that is an email chain with me and Mr. Chabavowski that Jen Janetsky agreed to dismiss as city case.
Yes.
That's part of the whole global resolution.
But okay, but that's a city case, not a state case.
Yes, that's correct.
That's correct. Okay, all right, understood. May I have him sworn?
Raise right hand.
You solemnly swear to affirm the testimony you're about to give and be the truth, the whole truth, and nothing but the truth, so help you God.
By God's law.
State your name, please.
Warner Victor Ali Thomas.
All right. Sir, this is court understanding you're going to be pleading guilty to the charge of attempted resisting and obstructing a police officer or first responder. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. Do you understand that?
Yes, I do.
All right. You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Garwood in the 15th District Court.
In her own. In her own.
Pardon?
In her own.
Say yes, sir.
So understanding all of that, how do you plead to that charge?
This is the critical stage of a global plea resolution, and the complexity explains why the judge repeatedly forces everyone to identify exactly which cases and counts are being resolved. Ali Thomas is expected to plead guilty to attempted resisting and obstructing, while multiple counts and separate district and city cases will be dismissed. He also agrees to restitution that may include losses connected to dismissed allegations. That can be lawful when it is knowingly incorporated into the negotiated resolution, but the amount still must be determined and supported rather than simply assumed. From the defense perspective, reducing exposure across several files to attempted offenses and a probation agreement may offer substantial certainty. The trade-off is equally serious. A guilty plea eliminates trial rights, sharply limits appellate options, and places sentencing before a different judge. That is why Judge Simpson cannot accept casual acknowledgments or vague responses. He needs an explicit plea and clear verbal confirmation that the waiver is knowing and voluntary. Did you notice how often the judge requests a direct yes? Informal confidence may sound harmless, but a deficient plea record can create grounds for a later challenge. Precision here protects the defendant, the prosecution, and the final judgment.
You understand that by pleading guilty, you will not have a trial of any kind.
You need a verbal answer, yes, sir.
Yeah.
You signed an advice of rights form or had one caused to be signed on your behalf?
Yeah, I have.
Do you have any questions regarding any of those rights?
No, I don't.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record?
Not at all.
Has anybody threatened you or coerced you?
Not at all.
You're doing this voluntarily? Is that a yes?
Yes.
Of your own free will?
Yeah. For sure.
Well, I'm done.
You had it. That's because he's not getting free now.
So, Mr. Bukovich, I'll give you 2 weeks to figure out how to tell your client to behave in my courtroom.
Yes, sir, Your Honor.
These proceedings demonstrate two different ways Judge Simpson manages legal risk. In Cummings' matter, he clarified the percentage provision on the bond, but preserved the no-go restriction until the homeowner's wishes could be verified. He also shortened the adjournment and allowed counsel to submit a written order sooner. That is a measured compromise. It addresses the defendant's ability to secure release and her claimed need to return home without treating counsel's account as a substitute for direct confirmation. Ali Thomas's hearing presents a different concern. The proposed global resolution could dispose of several cases through guilty pleas to attempted resisting and obstructing, dismissals, restitution, and a probation agreement. But a negotiated deal is not self-executing. The court must establish every material term and obtain an unmistakable, voluntary waiver of trial rights. The transcript ends with Judge Simpson stopping the exchange and directing defense counsel to address the client's courtroom behavior. Because the record does not clearly show a completed acceptance of the plea, viewers should not assume the agreement became final at that moment. The judge's response also illustrates why demeanor matters. Casual language, interruptions, or ambiguous answers can undermine confidence that a defendant appreciates the seriousness of the proceeding. Was Simpson enforcing necessary courtroom discipline, or could he have handled the moment differently? The broader lesson is that bond modifications require verified facts, while guilty pleas require exact language and informed consent. If you found this case as shocking as we did, Make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.